DOL fiduciary rule blocked. So, does that mean rollover advice just got easier? Not exactly. A recent federal court decision in Texas has changed the regulatory landscape, but it has not reduced your obligations. In fact, for many firms, the real risk hasn't gone away. It's just shifted. Here's what happened. The Department of Labor tried to expand fiduciary status. Specifically, they wanted one-time rollover recommendations, like moving assets from a 401k to an IRA, to automatically count as fiduciary investment advice. The court rejected that. Why? Because under ERISA, fiduciary status requires a regular basis relationship, and a single recommendation doesn't meet that standard. The court also made something else clear. The DOL cannot rewrite the statute, and it cannot turn ordinary sales activity into fiduciary advice by definition. So what's the result? Rollover recommendations are no longer automatically treated as fiduciary acts under ERISA. Sounds like a win, right? Not so fast. Because one very important thing did not change. PTE 2020-02 is still in effect. That means, if you are acting as a fiduciary, you still have to meet best interest standards, you still need proper disclosures, and you still need retrospective reviews. The difference now? Fiduciary status is no longer assumed. It has to be determined, using the traditional 5-part test. In simple terms, advice only becomes fiduciary if it's given for a fee on a regular basis, with a mutual understanding that it will be a primary basis for decisions and tailored to the investor. So now firms have a new challenge. You can't assume fiduciary status, but you also can't ignore it. You have to analyze it, case by case. Now let's talk about enforcement. The DOL's expanded framework is effectively paused, and many DOL-specific rollover disclosures no longer automatically required. But this is where firms can get into trouble, because the regulatory gap is not empty, it's filled by the SEC and by FINRA for registered investment advisors. The SEC fiduciary duty still applies to all investment advice, including rollovers. That means full and fair disclosure of conflicts and an ongoing duty of care and loyalty. For broker-dealers, regulation best interest is still fully in force, and it applies directly to recommendations, including IRA rollovers. Regardless of ERISA fiduciary status, that means you must act in the client's best interest, not your own. So what does all of this mean in practice? It does not mean you can relax compliance. It means you need to recalibrate it. First, reassess how you determine fiduciary status under ERISA. Don't assume it, but don't overlook it either. Second, keep documenting your rollover analysis, fee comparisons, service differences, alternatives, because even without a DOL mandate, these are critical under SEC fiduciary duty and regulation best interest. Third, align your supervisory systems. Don't treat DOL, SEC, and FINRA as separate silos. A unified framework is stronger and easier to defend. And finally, be careful with your messaging, internally and externally. If it sounds like you're lowering standards, regulators may hear something very different. So here are the key takeaways. The court blocked the DOL's attempt to expand fiduciary status to one-time rollovers. PTE 2020-02 still applies, but only when fiduciary status exists. SEC fiduciary duty and regulation best interest still govern rollover recommendations, and strong documentation and analysis remain essential. Bottom line, this is not deregulation, it's a reset. The responsibility to act in the client's best interest is still very much in place. At Legay Law, we make regulations make sense. For more regulatory updates, subscribe at legaylaw.com.